Record.
All right. Good morning to all. Can you two hear me?
Yes, sir.
All right. Fantastic. All right. We're here for our public deliberation for the three of us and Board of Appeals case numbers 21274 SPHA and CBA 2309. Project collectively we've referred to as Torch Hill. As you recall, we sort of had a hybrid responsibility here for the record appeal of the development plan. And then there was the variances that we also had to deal with. Those variances being the special variance through BCZR 4A02.4.G, and then the petition for variance dealing with the 0 foot setback, front setback in lieu of 25 feet. We heard a day and a half or a day and a quarter, or say, of testimony regarding the variance relief. And then we heard oral arguments on the purpose of the development plan. And the review standard for the development plan being BCC 32-4-2812 for a record appeal. We had, which seems to be par for the course, we had a late developing issue to be addressed. I guess we'll address it before we begin our deliberation. I believe Mr. McCann had included in his post-hearing memorandum some references to the Green Spring decision that was recently done before the ALJ. We received a letter, I believe, from Ms. Malone asking that be stricken. And then I think we received a response that I believe I just received this morning from Mr. McCann stating his opinion on that matter. So I guess we'll just discuss that briefly before we proceed. It's my understanding that when we had our oral arguments, that decision had not been issued as of yet. It's my understanding that it's a lengthy opinion, I think in the avenue of probably about 150 pages. I believe the time for appeal has not run, so that is an issue as well. And Mr. McCann makes the argument that a lot of the same issues and arguments that exist in that case exist in this one, which is correct, because I guess you could say the trilogy, starting with Blue Stem, this matter and that matter, are all dealing with a similar issue. So I guess the decision needs to be made on the record between the three of us, whether or not we're going to be considering the brief mention that Mr. McCann made of that case into his argument. Ms. Bernardi, your camera is off. I just want to make sure you're still with me. There you are. You can keep it off. I just want to make sure you can hear me.
No, in my view, everyone's camera was off, so that's why I turned mine off. So it must just be something with my technology.
Okay, that's fine. I just wanted to make sure you were still there. That's quite all right. Anyway, so thoughts on that issue? I'll pass it around. Mr. Pennington, thoughts on that issue?
Sorry, I was muted. Yeah, so just looking through everything, and it's my understanding that the time for appeal still has not run. I really didn't give that opinion much deference. To be honest with you, I don't think I'm considering it. I haven't considered it actually. So,
all right, Ms. Bernardi.
I have not given any consideration either.
Okay. All right. My thought on the matter was I completely understand why Mr. McCann would include it. He has basically been living these details for several years, and I'm sure it kind of all runs together with that. For issue of notice, when we have our oral arguments, basically the things that are then put into the brief are what we have at the time of oral arguments. As for, say, controlling case law, if there was a case out there You could put that always into your memorandum because that would be a settled case. But that is not, we don't give that type of deference to board opinions or to AOJ opinions, though they can be instructive for us. They're not binding precedent. So it doesn't matter in that situation. And also, I can tell you this, this was a pretty heavy lift of consuming what we had to consume, consuming another 150-page opinion, which would have to be done in its totality, I think, to appreciate whatever's been included in fairness, is something that I don't think we're prepared to do at this time. I can also say, too, that I believe I think it's a double-edged sword, actually, because it's my understanding that the finding, of course, the holding in that opinion was different than the AOJ's finding in this matter. So, I mean, it could go both ways. You could say, and she did this then, she didn't do that, or you could say she shows that she was thoughtful and that she, accepted that one, didn't accept this one. Anyway, as for that it be stricken, I'm not going to worry about it being stricken from anything. I think the three of us are going to concur that we're not going to include it in our consideration and have not included it in our consideration. And I think it can be left there. Are we in agreement with that?
Yes, Mr. Chair.
Okay. All right. So, all right, well, guess we get further into the nuts and bolts here. Is there a preference from either of you if we start with variances or start with development? Seeing no opinions being raised, I guess I guess we'll start with the development plan. Again, the review for the development plan is the BCC 32-4-2812, where basically it states that we're not to substitute our judgment for fact-finding basis, and there's a lot of deference that is given to the findings of the ALJ. So let me first, by way of this background, well, before I even get there, I wanted to express my opinion on the briefs were fantastic. I also want to commend Mr. McCann's history and this breaking down the elements of this consent order and the history. It's pretty fantastic, and I really appreciated the primer on what I'm going to call the alphabet soup of this case, because there's so much alphabet soup. But it was very informative. By way of background, I was on the board's blue stem decision. I did not write the opinion. Mr. Garber wrote the opinion because he's a far better writer than I. So, but I do recall, and just lay it out there about blue stem, those were the first case where these sewer issues were brought up. In that matter, the developer kind of relied on the Elm Street analysis and kind of deferred to county opinions as to whether or not there was capacity for the development that was proposed. And then Mr. McCann, who's been involved in the trifecta of these cases, put on Mr. Graycheck and really laid out an incredible amount of testimony showing why the assumptions that were being made by the county were incorrect. Important to note in that case that there was no rebuttal expert. There was no expert who challenged Mr. Graycheck's assessment to say that there was any compliance. So on our review here at the Board of Appeals, what I was really hanging my hat on is the deference to the AOJ in that matter, in that there was an expert who gave a lot of information, and that was pretty much unrefuted. There was an attempt to supplement the record in a case, I think, that was rejected, and that was part of our decision as well. But that's something that is important to note. There's been debate about the ALJ's reliance on blue stem. Blue stem is different because, it's the procedural part of it is different, and the testimony that was presented was different in that there was no basically challenge to the testimony. So getting to this matter, we have been provided with an incredible amount of material talking about the 2005 consent order. We've learned about SSOs and how the need to prevent SSOs. We've significantly been informed about the RKK and how they did the 2012 report, both the LTC and then the SRRR. And the SRRR that we found that was incorporated then into the agreement, basically of what was to be done. So there's been debate, I guess, as to which parts of those documents are controlling, which ones are recommendations and things of that sort. The difference in this case, again, is that in addition to the recommendation that I think from Mr. Bayer of the county saying that there was capacity for the 31 additional units, there was additional testimony given by Mr. Motzko, who was accepted as an expert. The Protestants Council has made it quite clear that he doesn't have great faith in the expertise of Mr. Motzko, and I understand that that's his job to make that argument. So what I'm setting up here is the way I see this for us on the record appeal analysis is that we have two experts. We have two expert testimonies that are coming to different conclusions. And the ALJ has made a determination through that evidence. And again, it's not our job to second guess her fact finding, but rather to see if there's a rational basis and whether a reasoning mind reasonably could have reached the factual conclusion that she did reach. So for me, that is our first discussion as to this matter. Rather than relitigating the entire development plan case, I think our charge as to the issue that has been made to be the most prevalent is to whether or not the ALJ was reasonable in determining that she sided with Mr. Motzko's interpretation. So that's where I'm going to set the table. And then I'm going to ask for some, well, first of all, I've set the table. Do my colleagues agree that that is how we should at least address that issue? Do you agree, Mr. Pennington?
Yes, sir.
Ms. Bernardi, your thoughts on that, do you think as well?
I agree as well.
Okay, great. All right, so I've talked a lot, so it doesn't seem like I'm filibustering the show here. Ms. Bernardi, do you would like to go first? You would like Mr. Pennington to go first to discuss his thoughts on the matter?
I can chime in first and then
Okay.
we can discuss back and forth.
Okay.
So as you said, I believe that the ALJ, when look at my notes, I mean, she had thoroughly outlined the testimony, the substantial evidence that was presented, her statements of fact. Her conclusion was well reasoned. She took into consideration the various things that you mentioned around the improvements of the Jones Falls sewer shed, with the blue stem case, the consent decree, the SRR plans you mentioned, and the various engineering assessments. She also considered the E. coli readings, the specimen tree variants. She even considered the residential performance standards and the school impact analysis, and open space considerations as well. And so based on that, I believe that a reasoning mind would reasonably reach the conclusions that ALJ Murphy did in this case.
All right, thank you. Mr. Pennington, sir?
Thank you, sir. I agree with Ms. Bernardi. The ALJ did a quite thorough job in outlining the history of the sewer problem starting in 2005 with the consent decree, and going, as I don't want to reiterate what you said earlier, Mr. Belt, but going through with hiring the company to come through and do the LTC report, and then follow up with the SRR, which was approved by the MDE and the EPA and incorporated into the consent decree. She went through that and then made a finding of fact that the SRR plan controls. Based on all the evidence in that case, I can't see how that was not a reasonable conclusion. And then she further went and I guess weighed the testimony between Mr. Grachek and Mr. Motzko. And Mr. Motzko I guess he testified that the items in the SRRR report were substantially completed. And I believe Mr. Grachek testified that he hasn't looked at anything since the Blue Stem case out there. So I can find that she reasonably concluded that Mr. Motzko's testimony with regard to what has been done is reasonable, and it's supported by substantial evidence. Also, and then with her findings, she also had the condition at the very end, which I agree with. I mean, she put the condition there that says the items that aren't finished in the SRR plan need to be finished as it relates to this project, the sewer line in this project, need to be finished before the project can be done. So I can't say that her findings are not supported by substantial evidence. I mean, as I said, as everybody said, there was a thorough job of weighing the evidence, presenting the evidence in the testimony. So I agree with Ms. Bernard.
All right, and it's noteworthy too, and it's been discussed, you know, you have the 2021 report, our next group of letters, I believe RGN report, updating some things that had been done. And I think Mr. McCann kind of admits that, I think he lobbies that there probably should be a moratorium, I believe is his thought, based on these findings on development there. But from what I find, there is no legislative moratorium. That's why we're having this discussion here. So each case is, you know, kind of rises, falls on its own facts, and it's fact specific to this development, this 31 additional units. And the ALJ's determination is based on this development and its effect on the sewer capacity. Not to say that the three of us would come to the same exact conclusion if in fact we sat for 3 days and heard from Mr. Grachek and heard from Mr. Motzko and heard their testimony and saw the interactions. We have transcripts and pieces of paper that we read, and that's basically what we review. And I believe there was a discrepancy that Mr. McCann brought up, because Mr. McCann, I mean, to his credit, Mr. McCann knows these reports probably better than really anyone. He's done a fantastic job and has a super command of the details. And I think there was that map 3 determination that he was thinking that the ALJ may have misread. I went back to the ALJ's opinion, and the mention of this map 3 is basically a small couple sentence paragraph and a very wider analysis of other facts on which her opinion was based. So I don't find that to be disqualifying as the entire decision of the ALJ on the fact finding that was done. And as both my colleagues have said, in the ALJ's decision, which it's always great for us when they actually lay out the factual findings, they're there. We don't have to agree with the inferences. We basically are bound with them unless we find them to be completely erroneous. And I must say that I've thought about this, you know, if this was, you know, talking about some sort of forest buffer or talking about a road condition or something, it's easy to go out and take pictures of it, you know, and look at it. But a lot of what's going on and being described is occurring on a subterranean level. So we're sort of accepting the testimony of others, which is really all expert testimony for us to figure out, you know, who is presented the best case and who we would hang our hat on to be believable. We didn't have to make that determination. The ALJ did, so we're sort of bound with that. So I think all three of us are in agreement as to our very limited review through BCC 324281 to I guess the word would be to affirm the findings of the ALJ as to the development plan. Mr. Pennington noted that there was conditional approval that was done by the ALJ, factoring in things that she requested to be completed in conjunction with the Torch Hill development. I would say that it would be thoughtful for us to incorporate those as well. All right, with that being said, we have a few variances to discuss. Let's just do the first less complicated, at least I think in my book, is, we saw this structure. I don't know what building, I don't know what it actually is or was, that basically sits on the road. It's been there for some time. I think part of the early plan for this, the county was suggesting that this building be kept. In order to keep it, it needs to have a variance because there's a zero front setback, needs to be 25. I think doing the Cromwell analysis for this one, for me, it's easy to find the uniqueness and part two to it as well. So that's my thought on that one. Mr. Pennington, your thought on that one?
I agree with you. I mean, obviously, it's property's unique, and then the hardship obviously would have to be, they have to tear the house down because it's been there for years and years, yeah, where it sits. So I agree.
All right, Ms. Bernardi.
I agree as well. It adds to the charm of the neighborhood, and there's a practical difficulty with removing it.
Okay, great. All right, for the one variance that is much more complicated because we rarely deal with them, is the special variance for the traffic for BCZR. I guess that's 4A02.4.G. And this is the variance needed because it is an F failing intersection. And one thing that was, interesting, with other variances like we just did with Cromwell, we have a clear roadmap as to what we are to consider. The roadmap for this special variance is a bit more confusing and muddy. There was a lot of discussion about the technology, the loaded cycle, the technology that's needed when they're doing the maps to determine whether or not a intersection is failing. So we know what technology was used to determine that it was an F. And that technology, from what the experts have told us, involves a physical counting of traffic at an intersection. So there's been a great debate about whether or not you're to use that same technology in order to get your variance. One thing that I think for me is interesting is that it's a variance, meaning that you're accepting that you're varying from the regulation that says that you cannot develop on the F. So there has to be a circumstance that you can, because it wouldn't be a variance if there was not. So if the intent was never to allow an F grade intersection to have development, then we would not have the need for a special variance. So the discussion, one thing that's resonated with me is using the previously described technology to determine the effect of this development on this intersection, I believe is impractical and impossible due to the fact that I believe you would have to create the conditions or build the development to see how it was. Hold on for just 1 second. Did we lose Ms. Bernardi? On my screen, we have. Am I mistaken? Brian, do you see Sherman?
No, I don't see her.
Well, we'll just wait a moment. Tammy, are you still with us?
I am.
Are you able to contact Ms. Bernardi by phone to see if she's okay or if she's having problems coming back in?
Yes, yes. I'll let you know.
Okay, thank you.
You're welcome. Mr. Bell,
Yes.
Miss Bernardi said she couldn't hear anything on her county computer, so she's going to sign in on another device. So she'll be back in just a minute.
Okay, great.
Looks like she's in now as an attendee.
Oh, right. Let me see if I can sort of
I'll unmute her
see
if
if
I
I can
can.
do anything about that.
Miss Bernardi, can you hear us?
Yes, I can hear you. Can you hear me?
Yes, we can.
Okay.
Thank you.
All right, you're back. I think I noticed immediately when you were gone, so we've stopped.
Okay, thank you.
And we're still, I was still speaking about the variance for the traffic for the failing intersection. And I was about to discuss this. We heard this de novo. So again, our review is going to be based on evidence that we actually heard. And we did hear expert testimony that was provided through the petitioner. And then Mr. McCann also brought, I believe, 4 witnesses or so dealing with surrounding folks who lived in the surrounding area who gave us their own firsthand experiences with that intersection. We also heard from Mr. Nebre, who's county representative, who was actually subpoenaed by Mr. McCann. And Mr. Nebre discussed basically his interaction with the traffic experts from the petitioner, talked about his thoughts on how there needed to be a net zero effect on the intersection. What Mr. Nebre could not testify to, and really wouldn't be proper anyhow, would be whether or not he believed there should be the variance itself. And he was even really unaware of the standard. He couldn't say for sure what the standard was for the variance, but it was his thought that there was to be a net zero impact due to the testimony that we heard that there was to be the 190-foot extension to the left turn lane, which was to be cut down on the queuing and the time for the light cycles, which we heard the expert opinion that would then create the net zero. From the community witnesses, we heard at different times of the day, especially around school time, because of St. Paul's being where it is in proximity there, that traffic was quite heavy and that it backed up from that light, not only at school time, but in sporting events at the school after school hours, that had a substantial impact on that intersection. So that is the testimony that we heard de novo in regard to the actual variance itself. So I guess the first determination we have to make, as it's not abundantly clear, is if the net zero standard is the standard that we use for determining whether to grant, Or is there a standard saying that it has to be improved and made better than the F? So that's sort of a fundamental principle. I fall on the interpretation of the net zero. Again, in my thought, for a variance, we're varying to allow you to have it. I'm not seeing in the statute or the code that it's requiring to be a improvement of conditions beyond of what they are at that time. I think it's more of a do no harm type of analysis. So I will defer to you and your thoughts on that one.
I agree with you.
Okay, I'm sorry, Brian. Go ahead.
Sorry, I agree with you. And plus, I mean, we had the experts testify that that's what the standard is, right? So I agree with you.
All right.
I agree as well. Like you said, Cornelius and Nebre both testified that that was sufficient, and we didn't need to consider that loaded cycle method.
Yeah. Yeah, as I said before, the LCM it just doesn't seem applicable for capturing something that would be a future hypothetical, since it's measuring conditions on the ground. Okay, so what wasn't brought up, it's just been mentioned, we had the variance that doesn't require the de novo with the specimen trees. I think Ms. Bernardi, you kind of referred to that too, basically in the analysis from the ALJ, that we defer to her findings on that. Other than the two variances in the development plan, is there any other housekeeping that needs to be covered?
Not to my knowledge.
All right, and Ms. Bernardi, are you satisfied that we've covered what we needed to go through?
Yes, I was just going through all of my notes, and we've covered what I've had as well.
Okay. I just wanted to state on the record, in our deliberation brief time that we have here together, just so folks know, I'm sure they would assume that, there's an extensive amount of hours that the board has put forth in reviewing the maps, reviewing the ALJ's lengthy opinion, Mr. McCann's very informative brief, the petitioner's brief. We have done our best to digest and to review everything that we could in coming to this decision. Again, as for the development plan part, it was not our job to relitigate the case, but rather to make a determination for a substantial factual basis for the ALJ to do so. And as for the de novo matters, we had the benefit of expert testimony and also the benefit of hearing from the community witnesses who took their time to appear during the hearing as well. So I just say that this case involved hours and hours of review, and we did not take it lightly in coming to our determination here today. And I thank my fellow board members for their efforts, making sure that we were prepared to discuss here today. And with that, I believe I'm going to sign off because I think there's a deliberation after us.
Thank you,
Thank you,
Mr.
sir.
All right, thank you all.
Take care.